Welcome, and thank you for joining us for today's Paid Family Leave webinar for employees. I'm Sarah McDonald from the Board Stakeholder Engagement Unit, and joining me today is Courtney Valet from our Office of General Counsel. Today, we'll provide an overview of New York State's paid family leave benefit as it pertains to supporting a military family member, including updates for 2025 and resources to help you if you plan on taking paid family leave. We will be using the chat feature to receive your questions today. You may enter your questions throughout the presentation in the chat box located on the right side of your screen, but we will wait until the end of the presentation to answer them. Courtney will answer as many of your questions as she can, but if you have questions that we don't get to today or think of something after the session ends, we will be providing you with resources at the end of the presentation. Your name and email were given to us when you signed in today. However, if you have a specific topic you'd like to discuss more deeply with the board, please share that topic along with contact information in the chat box so the appropriate board staff can follow up with you. The chat settings are set so only panelists can see questions or comments that come in, so you do not have to worry about others seeing your personal information. Before we get started today, we'd like to ask you to please keep in mind that the board is unable to provide legal advice, which includes guidance about what you should do in a specific situations. If you have specific questions or concerns about a request for paid family leave, you should contact your disability and paid family leave insurance, as they are the entity that makes the decisions to pay or deny benefits. Today, we will be sharing important information with you regarding New York State's paid family leave with a specific focus on military-related leave. Since its implementation in 2018, paid family leave benefits have been significantly enhanced to further improve the lives of working New Yorkers and their families, including providing more time off, more uses for paid family leave, and more financial security. In today's presentation, we will start by discussing why we need paid family leave and then cover some basics you need to know, including 3 original uses of paid family leave, an overview of the benefits, how much it costs, who's eligible, and steps you'll need to take to request paid family leave for military service. We will review some frequently asked questions about this type of leave, point you to some helpful resources, and leave time at the end for questions. So let's get started with a little background. Why do we need paid family leave? For too long, employees have struggled to maintain their jobs when they need to care for a loved one during a specific time of need, whether that's welcoming a new baby, caring for a family member with serious health condition, or dealing with family pressures when a loved one is deployed abroad on active military service. Employees in this situation face the stress of losing income when they need to take time off to help their family, and fear their job may be gone when that family situation is over. In response to these needs, New York took action. In April 2016, New York Paid Family Leave, the nation's strongest and most comprehensive paid family leave policy, was signed into law. Paid family leave is employee-funded insurance that helps employees be there for their family when they're most needed. Because of paid family leave, workers across New York no longer have to choose between caring for their loved ones and their jobs, as we now have employee-paid insurance to help in these critical times. New York State's paid family leaves provides you with a structure to help employees care for their families in times of need. Paid leave has been shown to increase workplace morale and employee retention. Fully funded by employee payroll contributions, New York State Paid Family Leave provides job-protected paid time off to employees who need time away from work to bond with a newly born adopted or foster child, care for a family member with a serious health condition, or assist loved ones when a spouse, child, domestic partner, or parent is deployed abroad on active military service. In addition to paid time off, New York's paid family leave also has strong employee protections. You are guaranteed to return to the same or comparable job after taking paid family leave. A comparable job is defined as a position with comparable employment benefits, pay, and other terms and conditions of employment. You are guaranteed continuation of health insurance while on paid family leave on the same terms as if you had continued to work. If you contribute to the cost of your health insurance, you must continue paying your portion of the premium while on leave. You are also guaranteed protection from discrimination and retaliation. Request or taking paid family leave cannot be held against you. Paid family leave benefits are available when you have a family member on active service abroad or has been notified of an impending call or order of active service abroad and family assistance is needed. Eligibility for paid family leave for an active service deployment is the same as the military provisions of the Federal Family Medical Leave Act, or FMLA. They cover your spouse, child, domestic partner, or parent. There are a number of instances where paid family leave will help here shown. Military deployment can be a stressful time for service members and their families as they face the realities of what this means for them. Military leave allows employees to be present and provide support to their family during this time of need, without having to worry about losing their job or financial security. Working military spouses have a difficult time maintaining long-term employment due to moves, deployment, and childcare. Having paid family leave eases financial strains, allowing military spouses to focus on their time on both work and family, while service members can stay focused on their mission and worry less about how to pay bills. And when service members return from deployment for rest and recuperation, R&R leave, paid family leave gives families valuable time to reconnect. Now let's look at the program benefits and contributions for 2025. Eligible employees are able to take up to 12 weeks of paid family leave at 67% of their average weekly wage, capped at 67% of the New York State average weekly wage. An employee's average weekly wage is based on their last 8 weeks of pay prior to taking paid family leave. For 2025, the New York State average weekly wage is $1,757.19. That means the maximum weekly benefit for 2025 is $1,177.32. This is $26.16 more than the maximum weekly benefit from 2024. The total maximum benefit of $14,127.84 if the employee takes all 12 weeks is over $300 more than 2024. It is important to note that employees can take this paid time off all at once or intermittently, but it must always be taken in full day increments. A wage benefit calculator is available on the Paid Family Leave website. Paid family leave is fully funded through employee contributions. The contribution rate is reviewed annually and is subject to change by New York State's Department of Financial Services. In 2025, the payroll contribution of 0.388% of the employee's gross wages each pay period. The maximum annual contribution is $354.53. This is $26.16 more than 2024. Employees earning less than the current New York State average weekly wage of $1,757.19 will contribute less than the annual cap of $354.53, consistent with their actual wages. To estimate deductions, you can use the 2025 payroll deduction calculator found on the Paid Family Leave website. So to summarize the benefits and contributions for 2025, the maximum weekly benefit is increasing from $1,151.16 to $1,177.32. Also, as of January 1st, 2025, employee contribution rate, employees will pay 0.388% of their gross wages each pay period, capped at an annual maximum of $354.53. This is about $20 more than 2024. Now that we covered the types of leave, the benefits, and the costs, let's review who is eligible to take paid family leave. Most employees who work for private employers in New York State are covered under paid family leave. If you work for a public employer, your employer may opt into the program. If you're a public employee represented by a union, you may be covered if paid family leave is part of your collective bargaining agreement. For covered employees, eligibility for taking paid family leave depends on meeting specific requirements for the amount of time employees have worked for their employer. Full-time employees, including domestic workers, who regularly work 20 or more hours per week, are eligible for 6 consecutive weeks of employment with the same employer. Part-time employees who work a regular schedule of less than 20 hours per week are eligible after working 175 days, which do not need to be consecutive. Citizenship or immigration status is not a factor in employee eligibility. Paid family leave coverage is not optional for eligible employees. You can waive coverage if you regularly work 20 or more hours a week, but won't be in employment 26 consecutive weeks, or if you regularly work fewer than 20 hours per week and won't work 175 days in a 52-week period. Seasonal workers are a good example of this, as they may work full-time, but only for 3 months out of the year. If you meet the criteria for waiving coverage, your employer must provide you with a waiver form, which is also available on the Paid Family Leave website. If you waive coverage, you will not make contributions and you will not be eligible for paid family leave benefits. Employers should keep a copy of your waiver on file. If your schedule changes, such as that you no longer qualify for a waiver, your waiver will be automatically revoked within 8 weeks of the schedule change. You can also voluntarily revoke a waiver at any time. If your waiver is revoked, your employer will begin taking paid family leave contributions and collect any retroactive amounts due. Military leave can only be taken for qualified exigencies when the employee's spouse, domestic partner, child, or parent is deployed on a. Now we'll cover how to request paid family leave for military-related leave, as well as how disputes and discrimination issues will be handled. When you're ready to request leave, there are 3 basic steps. Step 1 is to notify your employer at least 30 days before the start of leave, if foreseeable, or as soon as possible. Step 2 is to complete the request forms. Step 3 is to send all the required forms to the insurance carrier. The insurance carrier must pay or deny your request within 18 calendar days of receiving the completed request, or the first day of leave, whichever is later. You must submit your completed request package to your employer's insurance carrier within 30 days after the start of your leave to avoid losing benefits. Now let's take a look at each of these steps in a little bit more depth. Step 1 is to inform your employer. Let your employer know at least 30 days before your leave will start if it's foreseeable. For example, you may be planning on taking paid family leave if a family member is in treatment for cancer or recovering from a restorative surgery. If you need to take care of your family member unexpectedly and 30 days notice isn't possible, for example, in the case of a sudden illness or injury, notify your employer as soon as possible. Step 2 is to complete the required paid family leave request forms. For military leave, your request contains 3 forms. The first one, request for paid family leave form PFL1, information about you. The second form, military qualifying event form PFL5, requires information about the military member on covered active duty or impending call to cover active duty status. If the request is to meet with a third party, you may also have to fill out another section of form PFL5, the template for documentation for military qualifying event, form PFL5T, to provide supporting documentation of the meeting. You can get paid family leave request forms from your employer's insurance carrier, or directly from the paidfamilyleave.ny.gov/forms. First, we'll look at the request for paid family leave. Every employee who is requesting paid family leave starts with this form. It asks for basic information about you and the leave you want to take, and has a section for your employer to complete as well. You will submit this form to your employer's insurance carrier along with other completed forms for the type of leave you are taking. The request for paid family leave has 2 parts. You're responsible for filling out Part A, and your employer is responsible for filling out Part B. The first section of Part A covers your personal information, including your address, your social security number, or tax identification number, and your date of birth. You must also state why you're requesting the leave and how the family member it pertains to you pertains to is related to you. Next, indicate if you expect your leave to be a continuous period or intermittent. You may not know all the dates for certain, so you can indicate that they are estimated and then update your employer's insurer if a change is needed. Finally, you must provide information about your employment, including your employer's location and phone number, your date of hire, your average gross weekly wage, whether or not you have more than one employer, if you're taking paid family leave from the other employer, and if you're currently receiving workers' compensation lost wage benefits. You then need to sign and date Part A of the form and give it to your employer, who will then complete Part B of the form. Before giving this form to your employer, make sure to make a copy of the form. Your employer has 3 business days to fill out Part B of the PFL-1 form and return it to you. If your employer does not return the form, you can still proceed with your paid family leave request. Next, you must complete the military qualifying event, Form PFL-5. You will need to provide information about the military member on covered active duty or impending call to covered active duty status, including the military member's name, date of birth, gender, mailing address, relationship to you, the employee, time frame of active duty, and the reason you're requesting paid family leave. In addition, you must also select which supporting document you'll be attaching as proof that the military member is on covered active duty or impending call or order to cover active duty status. Supporting document: U.S. Department of Labor Military Family Leave Certification, also called the Federal Military Leave Form, copy of military duty papers, or other documentation supporting the reason for the leave. For example, a copy of a meeting notice or other meeting documentation, ceremony details, or rest and recuperation orders. You will need to include your name and date of birth at the top of the second page of the form and attest to whether or not you'll be including supporting documentation with the form. Finally, you must sign and date the form. The final part of the form is the template for documentation for military qualifying event, Form PFL-5T, and is used to provide supporting documentation when you are using the paid family leave to meet with a third party. For example, a meeting with a daycare facility or a financial counselor. You can make copies of this form and use one for each meeting that you are requesting paid family leave to attend. To complete this form, you must provide your name, date of birth, social security or tax identification number, and your mailing address. Next, you must submit the following information for each required meeting or event: name of the individual you'll be meeting with, their title, organization, phone and fax numbers, their email address, and their mailing address. In addition, you must also describe the nature of the meeting and include the dates if you know them. Step 3 is to send all forms to your employer's insurance carrier. Before submitting your forms, you have the PFL-1 and the PFL-5. You will submit the PFL-1, PFL-5, and Form PFL-5T to your employer's paid family leave insurance carrier or directly to your employer if they're self-insured. This address can be found in Part B, Question 13 of Form PFL-1. This is the section your employer completed. If the carrier's address is not on the form, ask your employer or contact the Paid Family Leave Helpline at 844-337-6303 for assistance. The insurance carrier must pay or deny within 18 calendar days of receiving your completed request, or the first day of leave, whichever is later. If for some reason your paid family leave request is denied, or you have another claim-related dispute such as the amount of your benefits or timeliness of a carrier's decision, you may request to have the denial reviewed by a neutral arbitrator. Your insurance carrier or employer, if self-insured, will notify you of the reason for denial and provide you with information about requesting arbitration. Arbitration for paid family leave is handled by NAM, National Arbitration and Mediation. For more information on arbitration is available at nyspfla.namadr.com. As mentioned earlier, your employer may not discriminate against you for requesting or taking paid family leave, and you are guaranteed job protection with the same or a comparable job upon return from paid family leave. Not return you to the same or comparable job, terminates you, reduces your pay and or benefits, disciplines you in any way as a result of you taking paid family leave, you can file a discrimination claim with the Workers' Compensation Board. An administrative law judge may order an employer to reinstate an employee, pay any lost wages, pay attorney's fees, and pay up to $500 in penalties. The process and forms are available at paidfamilyleave.ny.gov, or you can call the Paid Family Leave Helpline for assistance at 844-337-6303. There are a few frequently asked questions about paid family leave and other leave policies that may be helpful for you to know. How are PFL and FMLA similar? There are several similarities between New York's paid family leave and the Federal Family Medical Leave Act. Both provide bonding with a child, caring for a family member with a serious health condition, and assisting when a loved one is deployed abroad on active military service. Employees are also guaranteed that they'll return to the same or comparable position, and their health insurance shall continue on the same terms as if their employee had continued to work. If employees contribute to the cost of their health insurance, they must continue to pay their portion in premium costs while on leave. But there are several key differences. PFL is paid, FMLA is not paid. Almost all private employers will carry PFL insurance. FMLA does not include insurance employee threshold for eligibility. The length of time you must work is different. In PFL, if you regularly work 20 more hours per week, you must be in employment for 26 consecutive weeks for that employer. And if you regularly work fewer than 20 hours per week, you must work 175 days for the same employer, which do not need to be consecutive. For FMLA, you must have worked for a full year and 1,250 hours in the last 52 weeks to qualify. The biggest distinction may be that under New York's paid family leave, you are taking leave to care for someone else, not for your own health condition. FMLA allows you to take leave for your own health condition. PFL is only taken in full day increments, and FMLA may be taken hourly. Also, under PFL, you do not need to use other paid time off first. What is needed to demonstrate a domestic partnership? You do not need to have a registered domestic partner. You do not need to have a registered domestic partnership to take paid family leave to care for a domestic partner. The definition in the law is broad, and there are a number of factors that are looked at when determining whether a domestic partnership exists. These include, but are not limited to, common ownership of property, children in common, signs of intent to marry, shared budgeting, and the length of the personal relationship. For specific questions about what documentation you may need to submit to demonstrate a domestic partnership, you should reach out to your employer's PFL insurance carrier. Can military leave be used to take time off to care for a service member's child? Military leave covers making arrangements for the military member's child, as well as urgent, non-routine child care by the family member. This includes circumstances where the covered active service or call to covered active service status of the military members necessitates a change that may result in arranging for alternative child care, providing child care for a child on an urgent, immediate need basis, enrolling in or transferring to a new school or daycare facility, or attending meetings with the staff at school or a daycare facility. Ongoing routine childcare needs would not be covered. For example, an employee cannot take paid family leave to watch a service member's child during summer vacation. Can you take paid family leave to care for ill or injured service members or veterans? Yes. Caring for a family member with a serious health condition is a qualifying event for PFL. So you can request paid family leave to care for an ill or injured service members or veterans who are family members with a serious health condition. A serious health condition is defined as an illness, injury, or condition that requires either inpatient in a hospital, hospice, or residential facility, or continued treatment or supervision by a healthcare provider. Qualifying family members for family care PFL include your spouse, domestic partner, a child, stepchild, parent, parent-in-law, step-parent, grandparent, or grandchild. Under PFL family care, you can care for who has a serious health condition. How does PFL for family care differ from benefits administered by the U.S. Department of Veterans Affairs, or the VA? The U.S. Department of Veterans Affairs benefit is a federal program and does not impact or affect eligibility for paid family leave. Paid family leave for the care of an ill or injured family member who happens to be a veteran is different from the Veterans Affairs VA benefits in these ways. The benefit is for the employee, as the caregiver helping their ill or injured family member. The illness or injury does not have to be service-connected. The nature of the veteran's military discharge does not matter, and the illness or injury does not need a final diagnosis from the VA doctor or a VA rating to qualify. For example, an employee cannot take paid family leave to provide routine child care for a service member's child, but the employee could take paid family leave to arrange such child care. How do you plan leave when you do not know the exact dates? If you do not know the exact dates for when you'll need to take leave, inform your employer as soon as you do know when you'll be out. Complete and submit forms supporting documentation as soon as possible following the initial leave event. You have 30 days from the first day of leave to submit your completed request without losing benefits. If leave is taken intermittently, employers can require as much notice as practicable before each day of intermittent leave. Form PFL-1 also allows you to list estimated dates. It will alert the insurance carrier so it can inform you of any policies it has in place to notify the carrier when the exact dates are known. Remember that PFL must be taken in full day increments. Do you have to submit the entire form package each time you need leave? Submitting an entire form package each time you need leave will depend on each insurance carrier's processes and whether or not the certification covers the entire period. Section 204(1) of the Workers' Compensation Law states that if the events are separated by more than 3 months, they are different qualifying events and a new form package would likely be required. As we continue working closely with the employers to ensure successful implementation of the paid family leave throughout New York State, there are a number of resources to help. Complete details on paid family leave are available at the paidfamilyleave.ny.gov, along with other resources including paid family leave request forms and fact sheets, weekly deduction and benefit calculators, and updates for 2025. You can contact Paid Family Leave Helpline at 844-337-6303 for assistance. If you are not already subscribed for email updates on paid family leave, you can subscribe by clicking the Get Paid Family Leave Updates on the bottom of the paidfamilyleave.ny.gov page. New York State's paid family leave is administered by the Workers' Compensation Board. If you're not already following the board on social media, we have Facebook, Instagram, YouTube, and LinkedIn, so link up with us. You can also subscribe to get board updates on other benefit systems we oversee, workers' compensation and disability benefits, by hitting Get WCB notifications on the bottom of wcb.ny.gov. Okay, and we are going to take a few minutes to review your questions, and we will be right back with you.
So before we kind of get started with the Q&A, I just want to reiterate what Sarah said at the beginning. I am not able to provide legal advice. The board doesn't provide legal advice. So that's going to be something like claim-specific guidance or anything like that. For those types of things, you're going to want to talk to your employer's disability and paid family leave insurance carrier because they are the ones who are going to process and pay or deny the request for paid family leave. So the first question that I see here is that we noted in the presentation that military-related leave under paid family leave is the same as FMLA-related military leave, but FMLA doesn't cover the same family members compared to PFL, so domestic partners, siblings, blah, blah. So yes, this is a difference between FMLA and paid family leave for military leave, but I also want to kind of make it clear that military leave does not cover all of the same family members that like caring for a family member with a serious health condition does. The serious health condition leave, family care leave, is a broader list of family members. For military leave, it's for any qualifying exigency as interpreted under the FMLA. So there's where the FMLA comes in, is that the exigency is like the reasons that you can take military leave are the same under FMLA, but the family members are different. So it's the spouse, domestic partner, child, or parent of the employee when one of those people, spouse, child, domestic partner, or parent, is called abroad to active duty. So that's the difference between us and FMLA. But when we're talking about interpreting whether or not XYZ counts as a military exigency, we've adopted the FMLA rules for what those are. Okay, next question here is, I was advised by the insurance carrier that employees who live and work outside of the state are not eligible for paid family leave. Can they waive coverage as well? So they cannot waive coverage because they're not covered. So a covered employee, in order to be considered in employment and to gain eligibility and be able to take paid family leave, they have to be what's in employment in New York State. And in employment requires that an employee be what's called localized in New York. Their service has to be localized in New York. If they never work in New York State, so say like it's a New York State based employer, but they have employees in Massachusetts and Connecticut, and those employees work in Massachusetts and Connecticut all the time, those employees are not covered for New York State paid family leave. And they don't waive coverage because they're just not covered. They don't count under the definition of employee in employment. Next question here is, can an employer pay an additional wage to offset so that the employer gets 100% of their wages instead of losing 33% while they're on paid family leave? What can the employer do so their worker isn't losing money? So there are kind of two main options if an employer wants to do this. Firstly, I just want to say the employer is not required to do this, but if they want to make their employees whole so that they get 100% of their wages during a period of paid family leave, they're completely free to do so. So the kind of two options would be, if you pay full wages to your employee during a period of paid family leave, on the PFL form, you'll see there's a box to check. If you're paying wages, you can request reimbursement. And so how that works would be, you're paying your employee 100% of the wages. The employee can't get more than 100% of wages during paid family leave. So essentially the carrier would be paying the benefits to you. So they're reimbursing you for paying out that 100%. The other option would be that an employer can top up, we call it, an employee's paid family leave benefit. So they're getting that 67%. The employer can give the employee the extra 33% so that they get 100% of their wages. I do just want to make it very clear that the employer cannot force the employee to use accruals during a period of paid family leave. But if they want to pay them full wages, request reimbursement, or if they want to just pay that extra 33% on top, they're completely free to do so, but they're not required to. Okay, next question here is, can an employee use this to care for their grandchildren if the employee's son or daughter is deployed abroad? So I know this came in kind of before we touched on it in the presentation, but that childcare related activities for military leave, you can arrange for alternative childcare. You can provide childcare on a non-routine, urgent, and immediate need basis, but it cannot be kind of this routine, you're their new babysitter for 12 weeks while the employee is deployed abroad on active military service. So it does have to be kind of arranging for childcare or a very urgent thing while you're looking for someone else to become the babysitter or something like that. Okay, next question here is, if an employee is on paid family leave and they don't go back to work after the leave expired, can we terminate them right then and there, no extension? So I can't provide legal advice. That includes guidance on your business practices. I would just kind of tell you to keep in mind that employees are entitled to reinstatement to the same or comparable after a period of paid family leave, and you are also prohibited from discriminating or retaliating against them because they took or requested paid family leave. But I'm not going to be able to provide legal advice. If an employee thinks that you have discriminated or retaliated against them or failed to reinstate them, something like that, they're free to file a discrimination claim that would be heard before a workers' compensation law judge. And then the law judge would make a determination. The employee would have the ability to present their evidence, and you'd have the ability to present your evidence, but it would be up to the workers' compensation law judge to make a determination. Okay, next question here is, can someone be eligible to take paid family leave for family care if the employee can show that he or she is the sole caregiver of their aunt? So an aunt is not a family member under the workers' compensation law currently, under the paid family leave law. So to change the definition and to add family members, that would require a change to the law. So currently, an employee's aunt or uncle, they are not considered family members under the law. Okay, next question here is, so a remote employee working from outside New York State isn't eligible for paid family leave. So this is going to be an extremely fact-specific question, and I can't provide legal advice, and that does include eligibility determination for particular individuals. But to be eligible for New York State paid family leave, the employee does have to be localized in New York State. And I'm going to put a link in the chat here right now, just to give you, it's section 201, 6B and C has the test for localization. So there's the link, and then it's 201, 6B and C for the localization test. So it is a test that's actually in the law, and to be eligible for New York State paid family leave, one of the requirements is that you have to be in employment with a covered employer in New York State. Okay, next question here is it correct to say that 60-day eligibility can be used intermittently within a year? So for example, 5/21/25 to 5/21/26. So again, I can't provide legal advice. That's going to include specific questions about a paid leave, specific questions about eligibility, things like that. But intermittent leave, how many days of intermittent leave an employee can take is going to depend on how many days a week they work. So if we're talking about someone who works 5 days a week, like many of us do, they're going to be eligible for the equivalent of 12 weeks, which would be 60 days. But it's going to depend, it's 12 times however many days you work a week. That's going to be your eligibility for intermittent leave, because that's the equivalent of 12 weeks, which is the maximum. And then there is, in the regulations, it does say a single claim can only span for 52 weeks, I believe is how it's written. It's either a year or 52 weeks, but I think it says 52 weeks. So if there's, for example, like caring for a family member with a serious health condition that's ongoing and it goes on past the year mark, the employee is likely going to have to apply again. And then just keep in mind, they do have that maximum of 12 weeks or the equivalent intermittent days of leave that they can take in any 52-week period. And that is based on a rolling calendar. Okay, next question here is, employers can't force employees to use their accruals, but what if an employee wants to? Can the employer allow that? So yes, with the caveat that employees cannot receive more than 100% of their wages. So if we're talking about topping up something like that, an employer could allow them to use partial accruals to achieve that full wages, but that would be an agreement that the employer and employee makes. So they can't receive more than 100% of their wages. Okay, and then I see a kind of related question here asking if an employer could allow the employee to use some of their PTO along with their PFL. So like we just talked about, yes, but you cannot force it. But if you wanted, if you and the employee agreed you're going to use partial accruals to top full wages during a period of PFL, that's fine. You just can't receive more than 100% of your wages. Okay, next question here is FMLA required to be used while out on paid family leave? So generally speaking, available FMLA and PFL for the same qualifying event are going to be taken at the same time. So the default in the PFL law is, unless the employer says otherwise, available FMLA and PFL for the same qualifying event are going to be taken at the same time. So when we talk about available FMLA, FMLA has a much longer eligibility period than paid family leave. So it is conceivable that someone becomes eligible for paid family leave. Their employer is subject to FMLA. They're going to take paid family leave. FMLA is not going to run at the same time concurrently with that because they're not eligible for FMLA yet. Another example would be like if someone took FMLA to care for themselves, so their own serious health conditions, so now they have no more FMLA remaining to them, but they have a PFL qualifying event. You know, one of the three that we've been talking about. Just because you don't have any FMLA available to you doesn't mean that you're not going to be able to take paid family leave. They are separate benefits with separate eligibility. It's just if it's available to you, and you know, bonding leave is a big example. Bonding leave is for both FMLA and paid family leave. Same with what we've been talking about with military leave. The reasons are the same. As long as it's the same qualifying event, so same person, same qualifying event, and you have both available to you, your employer can require you to take them at the same time. Okay, next question here is the eligibility strict when it comes to number of days or number of weeks worked? So what if someone only has 170 days worked? Are they eligible, or do they have to complete the 175 days? So the eligibility is in the law and regulations. So those are the eligibility. There are no exceptions to that. So the employee does have to be eligible in order to have a request for paid family leave be approved and paid. Okay, I see some very specific questions about can they use sick time, vacation time, just PTO. That's really going to kind of cross into legal advice. And like I've said kind of a few times here, I cannot provide legal advice. Okay, next question here is, if the employer is subject to FMLA, can the employee choose not to use FMLA while out on PFL and only receive PFL? So the answer is no, unless the employer allows it. So the employer is the one, the default is available FMLA and PFL for the same qualifying event is going to be taken at the same time. So you're going to get that 12 weeks. If you're taking all 12 weeks in this example, you are. So you're taking all 12 weeks and FMLA is available and paid family leave is available to you. After that 12 weeks, you're going to have all of your FMLA and all of your PFL for that 52-week period is done. It's exhausted. The employer can allow the employee to not use FMLA, but they don't have to. So it's unless the employer allows otherwise, they are going to run at the same time, except for the kind of the exceptions we talked about before. If like it's not available, if it's a different qualifying event, if you weren't eligible, things like that. Okay, next question here. What happens if the worker exhausts their paid family leave time and all of their accruals and they still cannot return to work? So this is really outside the purview of the paid family leave law. So time away from work that isn't PFL, that's kind of going to fall into the employer's normal leave policies. You just want to keep in mind, you cannot discriminate or retaliate against your employee because they take a request to paid family leave. If they believe that you've done so, they can, again, do the discrimination claim, and then a workers' compensation law judge is going to take a look at it and make a determination based on all of the evidence and facts provided by the employer and the employee. But what happens when it's not paid family leave and the employee is not at work is outside the purview of the PFL law. Okay, next question here is, if I already used 12 weeks of paid family leave, can I apply within the year? If not, when will I be eligible again? So I'm just going to reiterate this again. I can't provide legal advice, and that does include eligibility determinations. But to kind of answer in a general sense, the maximum amount of paid family leave that any employee can take in any 52-week period is 12 weeks. So if you take 12 weeks of paid family leave, you cannot take any more within that 52-week period. It is based on a rolling calendar. So the carrier, like if you apply for leave, the carrier is going to look back for each day and see how much leave has this person taken. If it's 12 weeks, you're not eligible. If it's less than 12 weeks, you may be eligible up to the 12 weeks. So it's 12 weeks in any 52-week period, meaning that rolls along. It's not January 1st to December 31st. It is a rolling 52-week calendar period, and you can only take 12 weeks during that 52 weeks. I did also just want to add kind of to that answer and some of the other answers I've been talking about with the maximum, to also just keep in mind that there is a statutory combined maximum of 26 weeks of paid family leave and statutory disability. So sometimes that does come into play. So that's something else to keep in mind, and that's also within any 52-week period. Okay, next question here is an employee who was employed for 7 months, took paid family leave, and was approved. Then when they're eligible for FMLA, can they apply for another set of PFL now that they're eligible for FMLA? So not related, except that available FMLA and PFL for the same qualifying event can be required to be taken at the same time. Available is the key word here. If the employee has already used all 12 weeks of paid family leave, they are not eligible again during the rolling 52-week calendar period. They've used their maximum paid family leave. FMLA, we don't have jurisdiction over it. FMLA is a federal law, so we don't have jurisdiction over it. But again, like the 12-week maximum it's set in the law, like that's what it is. You're eligible for a maximum of 12 weeks of paid family leave in any 52-week period. And then subject also to the combined 26 weeks for disability and paid family leave. Okay, I don't see any other questions, but if you have them, put them in the chat. We'll hang out another minute or two, see if anybody has anything else.
All right. Thank you, Courtney, and thank you everyone for joining us today. I did see a question in the chat about the presentation, and I just want to let you know there will be a recording of this presentation available on the board's YouTube channel within the next week or so. So just keep an eye out for that there. You can also sign up to receive paid family leave news, including information on future webinars, straight into your inbox. To sign up, visit the paid family leave website, scroll down to the bottom of the homepage, and select Get updates. We also distribute information via our social media channels, so please follow the Workers' Compensation Board on Facebook, X, Instagram, and YouTube. We thank you all for joining us and enjoy the rest of your afternoon.